Hello, my name is Chris and welcome to our When Land Meets the Sea podcast, a coastal mini-series by David Jones Bold. On this podcast, Richard and Lizzie take a road trip around the coast of England and Wales and visit some of the most significant cases and legal issues relevant to the coast. UK coastal towns are some of the best places in the world to be, but they also face major challenges, faring disproportionately worse than inland towns and cities for health, education, socioeconomics, crime, and more. Through this group, we are working to change that. For example, we recently worked with the government to get coastal communities added to the list of mayor competencies under the English Devolution and Community Empowerment Act 2026. We've also developed a framework for coastal placemaking and stewardship, which you can download for free at www.djblaw.co.uk/blue-horizons. Enjoy the podcast.
Hi, Richard.
Hello, Lizzie. How are
Hello.
you?
I'm very well, thank you, particularly because I hear we're going to be actually on the beach for this
On the
episode.
beach, yeah. Mm-hmm.
And we're going to talk about things you can and can't do on the beach. We've got a case to talk about.
Case
Do you
or
want
two.
do you want to start with a bit of background? Why are we talking about this?
Well, it's not just on the beach, it's about foreshore, which we have touched upon when we were looking at accretion and diluvium. But I'll go back to 1854 to start off with. A case called the Attorney General in Chambers from South Wales, from Llanelli, and so not specifically about the beach, but Chambers owned land near the coast, and they were involved in coal mining, and they dug obviously downwards on their land, but then went underneath the foreshore and were basically mining under the sea. And the Attorney General, acting on behalf of the Crown, argued, you can't do this, you owe us royalties, you're trespassing, because it's our foreshore, and all the land down below will be ours as well. A lot of foreshore is owned by the Crown, not all by any means, but the AG and Chambers case said that the prima facie presumption is that if you can't show otherwise, the Crown owns the foreshore. And they, in this case, also define the foreshore as the medium mark between high and low water. So, in fact, Chambers had been, it's not just the land itself. There's that old thing, that old rule of Cius solum iestos cad quaelum et enum feros that you'll be aware of. Remember that one?
Yes, don't think I'll ever be able to repeat that to you, but
It's basically if you own the land, subject to a lot of provisos, you own up the sky, up to the heavens above and down to the depths of the earth. And so you're trespassing. And this is our foreshore, so they had to pay royalties. And that's quite a significant case here. I mean, there was nothing to do with the coast, but there was a case, Bocardo and Star Energy 2010 case, which pretty much the same thing about oil, drilling for oil. And going down and then under neighbouring land, and you would be trespassing even though you were up to 2,900 foot down. There was only nominal damages, but another example thereof. So bearing in mind there's a lot of foreshore out there, what are you allowed to do on the foreshore? Under ancient custom, you're allowed to perhaps to navigate by foot on the foreshore. You can walk along it, and you can fish, sea fish, off the foreshore, and that includes tidal estuaries and the likes, as long as they are tidal. But there was a case, a controversial case, but still quoted, a case called Blundell and Catterall in 1821. Shall I tell you about that one?
yes, please tell us about it.
Well, it all took place in Great Crosby in Merseyside. I think it's in Sefton district, just north of Liverpool. And they basically what had happened is it was a private owned foreshore, not Crown. The William Blundell was the lord of the manor of Great Crosby, who owned this foreshore. And Catterall was a nearby innkeeper who had a lodging house. And what he would do is cross the foreshore, not just navigating it, but crossing it with his bathing machines. Do you remember? Well, you won't remember them before your time.
A bathing machine?
Yeah, they were in the they were used until the early 20th century, but late 18th. It's when sea bathing sort of took off for the first time, but men and women were not allowed to mix together. And, you must have seen pictures of people
Yeah.
bathing in Victorian times with fully clothed with tweed jackets or something, I don't know. Basically you'd bathe from these bathing machines, which would be taken across the foreshore, placed into the sea, and then people would be able to bathe in modesty. And Blundell, the Lord of the Manor, wanted to stop this. And the King's Bench Court, which is now part of the High Court and has been for many a year, but they basically said that you might have a right to navigate across the foreshore, the beach, if you like, between high and low water, Mark, but you have no right to fish, as perhaps we'll come back to, but you've got no other rights whatsoever, including no right to recreation. And so they were trespassing. And that was Blundell and Catterall all those years ago. I mean, things have changed quite a lot. And one of the changes was in the news earlier this year, actually, on March the 19th, which is, well, there's, that the whole of England and Wales is surrounded by, it's not quite finished yet, but by a coastal path now.
Yeah.
The Welsh one, the Welsh coast path's been around since 2012 and stretches from Burton Marshes, which are north of Chester, I know well actually, and all around the Welsh coast to Chepstow, 870 miles. But then the English path, I say there's still work to be done, but the final stages of it, King Charles III, England's coast path, was opened on March the 19th by King Charles III himself. There's a few exceptions, obviously, like military areas and houses and this kind of stuff, but you've got a right to walk right round the coasts of England and Wales now, starting in England at the Seven Sisters in Sussex, near Beachy Head. And that includes, it's only for recreation purposes, and it's only sort of on foot. Not horses and not bikes and not cars and the likes, but you can walk to the seaward side, on headlands and dunes and beaches and this kind of stuff. You've got an absolute right to walk between the path and the seaward side all around the country now. With, again, a lot of exceptions. You don't do it around a military explosive area if you've got any sense. But, and there's other provisions that, Section 34 of the 88 Road Traffic Act, which used to be in the 1930 Road Traffic Act, says things like you can't drive vehicles more than 15 yards. They still refer to yards from the highway. So, driving vehicles is... it's without lawful authority, but can be a criminal offence if people haven't actually, the owners either expressly or impliedly allowed you to be on the land. And some parts of the country, you are allowed to park on the beach.
Got to keep an eye on the tide times, though, haven't you?
Yeah, as my granddad found out many a year ago. One of them is just north of Great Crosby, actually, in Southport. That do you know Southport?
Not really, no.
It's just because the sea has been receding and the land's been accreting, or if that's the right word, and it's got a huge, it's certain times of the day the sea is a couple of miles away. And for years, just through custom, no one seemed to have stopped them, that people would park their cars there. It's now a car park, actually. The council have decided to make it into a car park so they can charge money. And it's where my granddad's Morris Traveller, if you remember from a previous podcast, met its death. It's probably still there, actually, if you ever see a little bit of a Morris Traveller. Somewhere on Southport Sands, that's what it'll be. There's another one closer to you, actually, Breen.
Yeah, Breen Down.
Breen Down, people can park there, can't they? I think that's a car park now as well, an official car park. But that's where it's been permitted. Otherwise, it seems that you don't have any specific rights to do anything but navigate and fish. Shall I mention fishing, what you can do in terms of sea fishing?
Yes, please. Tell us about it.
People say it was in the Magna Carta, and it's not. I was going to say it's in Clause 33 of the Magna Carta in 1215. What Clause 33 basically said is that any fish weirs will have to be removed from land, and the Crown wouldn't have any right to give people the right to put fish weirs in. Fish weir was basically to sort of catch fish, if you like, in tidal areas, like parts at the time of the River Thames. Unless, and here's a topical thing, Lizzie, didn't realise this until a short while ago, or I knew the date, but unless you could show you've been using it as a fish weir since time immemorial. And time immemorial was set by the first Statute of Westminster in 1275 as 1189, the year 1189. Do you know why that was the case?
Please, can you tell us?
It was the date of the accession of Richard I, Richard the Lionheart, to the Crown of England, on, and get this is spooky, July the 6th, which is today.
Which is today.
Yeah.
That's serendipity, isn't it?
Yeah, that's something.
It was meant to be, this podcast.
Yeah, synchronicity, I think the word. July the 6th at 1:35 in the afternoon. I got no evidence it was 1:35, but anyway. There's actually an Irish case called by the House of Lords, but Malcolmson and O'D, if that's the way you pronounce it, in 1863, which have basically said this gives a right, unless it's from Crown foreshore at least, to fish, sea fishing, including tidal rivers. This was the River Shannon in Ireland, a tidal part of it, unless people can produce evidence that it's been blocked from used as fishing in private fishing since 1189, which I won't go into because it's incredibly complicated and rather bizarre. But they basically the two of them seem to be expanded upon. You can't have fish weirs, but you've got to allow sea fishing, including on the foreshore, on the beach. You don't need a license. There are exceptions, like migratory fish, salmon, sea trout and the likes. But otherwise, you've got an absolute right to fish from the beach and on the sea generally. You need a boat, it's a bit different. But you've got this absolute right to fish based on the Magna Carta, but not actually in the Magna Carta. And that's a bit of it. That's what you can do, an absolute right, much expanded by the Marine and Coastal Access Act of 2009, in terms of being able to walk to the seaward side for recreational purposes.
Well, there we go. If anybody's going to the beach in the heat wave this week, now they'll know what they can do.
Yes, you're absolutely right. But don't take your car, unless you're at Southport or Breen and somewhere in North Wales as well.
Excellent. Thank you very much, Richard.
My pleasure as always, Lizzie.